And cause number 22-41144 is recalled. The state of Texas versus David Allen Tovar. The defendant is present with his attorney and the state's attorneys. Earlier in this case, the defendant was found guilty by a jury trial of the first-degree felony of continuous sexual abuse of a child. Arrested.
This charge, continuous sexual abuse of a child, is one of the most serious in Texas law. It carries a minimum of 25 years with no parole eligibility. That means the jury's punishment decision isn't just about guilt. It's about whether this man will ever walk free again.
Over the weekend, returned back today for presentation of evidence for the punishment phase. The jury was instructed, the lawyers gave their final arguments, and the jury began deliberations on the punishment phase of this trial. We have received a message from the jury that the jury has reached a verdict in this punishment phase of the trial. Please bring the jury in and we will receive it. Thank you. Alternates? The record shall now show that the jury is in the courtroom and Miss Libby, on behalf of the jury, as the foreperson of the jury, the court has received a message that the jury has reached a verdict in this punishment phase or second phase of this trial. Is that true? Is this decision and verdict a unanimous one? That is.
Notice how the judge is confirming unanimity. In criminal cases, especially at sentencing, every juror must agree. No split votes, no majority rules, it's all or nothing.
One that is agreed upon by all members of the jury. And do any of the jurors disagree with your foreperson's representations? No disagreement. It does indeed appear to be unanimous. This time I'm going to ask you to pass the documentation to the bailiff. The court will review for proper form and publish the verdict. The defendant shall rise. In cause number 22-41144, the state of Texas versus David Allen Tovar, we, the jury, assess the defendant's punishment at confinement in the Institutional Division of the Texas Department of Criminal Justice for
28 years. Let that sink in. The jury could have gone much higher, even up to life, but they settled here. Do you think that reflects mercy, compromise, or doubt? Drop your thoughts in the comments. Was 28 years enough?
Term of 28 years, signed by the jury foreperson, and it is received and made a part of the record for all purposes. The defense may be seated. Ladies and gentlemen, at this time, your duty as jurors is complete. At the beginning of the trial, I placed each of you under a number of instructions, and I am releasing you from those instructions previously given to you. One final instruction, though, added. Once you are discharged, you are released from your oath of secrecy. You will be free to discuss.
Here's a fascinating legal moment. Once jurors are discharged, they're free to talk about deliberations or keep silent. Ever wonder what really goes on behind those closed doors? Imagine the debates that led to 28 years.
The case and your deliberations with anyone. And conversely, you are also free to refuse to discuss the case. You have every right to maintain your silence unless otherwise ordered to do so by the court. Now, once you are discharged, the attorneys need to take up a couple of matters here, then they will be released. And they always like to get input and feedback from jurors if you're willing to stick around and speak to them. It always helps them to be a better lawyer, and it's always helpful. But you are also free to leave as well. And that is completely your prerogative. It's never easy making judgment on a person. And in fact, the New Testament talks about judge not lest ye be judged. But the burden of proof beyond a reasonable doubt came into being in America in 1770 based upon the New Testament because jurors were worried about, what happens if I make a judgment decision? Isn't that judging? Judge not lest ye be judged. And historians as well as experts of uh, biblical rules determined that in a democratic public where we, the people, get to make decisions, we have to make judgmental decisions. And these are judgments that have to be made. We don't have a machine that makes a determination. And until someone can come up with a better idea, I always believe that the people who come forward for jury service and make decisions do it with their best intentions. And because of that, the bar is high beyond a reasonable doubt and is the test that is used in all modern governments that we came up with to answer those concerns of people. So I want to thank you for your time and energy and the seriousness that you took this. But these are important decisions. They're always difficult decisions. But we all want a decision made. There's nothing really that concerns us more than having to retry the cases. And it's a rare event when that happens, when there's a hung jury. But it can happen. But I want to thank you for doing your job and coming forth with a unanimous decision. Now, Lacey has documentation there. My coordinator.
The judge is walking the jury through history here, tying the American beyond a reasonable doubt standard to biblical teachings. This isn't just legal doctrine, it's storytelling to remind jurors their role is sacred.
Has documentation if you need it for work or school or other purposes. And the attorneys will be out shortly after we take up some matters that need to be taken up. I hope to have the honor to work with you in the future. And until then, may God continue to bless Jefferson County and her citizens. And not only to you, but also the alternates who kind of dress up with no place to go. But we have had to use alternates about one every 4 or 5 cases now. So thank you for your time and energy. And I can guarantee if we didn't have an alternate, if we lost one, the rules say you have to have 12 or else it's mistried. So you can see how important an alternate is. So thank you all for your time and your energy. And again, I hope to have the honor to work with you in the future. And you are excused. Thank you. Everyone else remains seated while this honorable jury takes its first. Thank you. Joe, you were going to take a souvenir home there, were you?
Yeah, I was hoping. My sight and sound were still written VHS tapes.
Oh, okay. Thank you. One of the great radio broadcasters of our time, Joe Zach. All right. Is there any legal reason why a formal sentencing should not be pronounced at this time, defense and state?
No, yeah.
David Allen Tovar, you came before this court and a jury, entered a plea of not guilty to the offense of continuous sexual abuse of a child, as set out in this indictment in cause number 22-41144. The evidence was submitted. The jury was charged by the court. After deliberating, the jury returned a verdict finding you guilty of this first-degree felony of continuous sexual abuse of a child. And thereafter, punishment evidence was submitted before the jury. The jury was charged and assessed your punishment at confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 28 years. Is there any legal reason at this time why formal, final sentencing judgment should not be assessed by the parties, either the state or the defense? Then it is the judgment of this court that you are guilty in this cause number 22-41144, the state of Texas versus David Allen Tovar, for the first degree felony of continuous sexual abuse of a child. And you shall be punished in accordance with the jury's verdict. Your punishment is therefore assessed at confinement in the Texas Department of Criminal Justice's institutional division for a term of 28 years. You shall therefore be delivered by the sheriff of Jefferson County, Texas, to the director of the Texas Department of Criminal Justice's institutional division, or any other person legally authorized to receive such convicts, where you shall be confined for 28 years in accordance with the laws governing the Texas Department of Criminal Justice's institutional division. David Allen Tovar, you are here now remanded to the custody of the sheriff of Jefferson County, Texas, until she can obey and carry out the directions and instructions of this sentence. Your sentence will commence this day. You will receive credit for all time periods of detention as provided by the law. Anything else to add from the state or the defense?
No.
All right. Can you make sure, Mr. Wilkerson, that he has documents filled out in the event he wishes to appeal the sentence?
Yes.
This is not a plea bargain case. The defendant does have the right to appeal this finding in the guilt or innocence and punishment phase of this case. I'm signing those rights and privileges, and please get the copy, each party, from the coordinator. Anything else to add?
No, Your Honor.
If not, we are in recess on this case.
Effective impact statement.
All
From
right.
the Your Honor.
All right. Because this involves continuous sexual abuse of a child, the court will embark on this presentation and will return later for the next hearing.